Welcome to the DeFi Standard, and I'm Mickey B. Fresh, and today we're going to dive into the unethical activities of the SEC and their intimidation tactics that they are trying to pull on Ripple and also behind the court's back. So what they have done here is they're digging their hole worse and worse with what they're doing. So we're going to go through some documents that were filed by Ripple briefly, and we're going to go through a Wall Street Journal article that actually has shined light on the SEC's abuse of power, basically. And also, John Deaton wrote an excellent blog post here from Crypto Law that we're going to go over, and we're going to see exactly what this means for the case and what are the potential consequences for the SEC and how does it play out in the future. So let's really get right into it here, because Ripple has a really good point. They're literally trying to intimidate Ripple or trying to gain information because they went into 3 specific jurisdictions where XRP has the most clarity: the UK, Japan, and Singapore, where they all have deemed XRP to be a currency. And now, no jurisdiction has ever deemed XRP to be a digital security, but these jurisdictions are the most friendly. Now, they issued subpoenas to those governments to ask those financial institutions that are under the jurisdiction of those governments to produce certain documents. And now they did not tell Ripple even what those are. They gave them just a broad overview. So they're really acting like a rogue, basically like a mob mafia of the world, basically here. And Judge Netburn, in the past, just want to reiterate here that she threw out the attempts by the SEC to gain access to Brad Garlinghouse and Chris Larson's personal financial records. She threw that out from discovery. And then she also allowed Ripple to gain access to SEC internal communications between staff and the higher-ups at the SEC, and also communications between the SEC and third parties like your Coinbase, your Bitstamp, or any market makers or any entity that's looking to do business using XRP or Ethereum or Bitcoin. They're getting all those communications. So I think there's a good chance there's going to be a smoking gun there, if not multiple of those, where the information, Ripple, I feel like, kind of has an idea of what was said. And I just want to throw this out there before we get into what's going on with this. Coinbase just IPO'd. Now, Coinbase did not list XRP throughout 2017, 2018, when everybody was just on top of Coinbase saying, hey, list XRP. Why are you not listing XRP? And Coinbase, didn't respond. They never listed it. Now, in early 2019, they decide we're going to list XRP on Coinbase and Coinbase Pro. And then they even did it in New York, which is probably one of the most strict states of all. And here's the kicker. Who was general counsel at Coinbase during this time in early 2019? Brian Brooks. So I just want to reiterate that there. So there's probably multiple communications that it's possible that Ripple already knows about that are going to come out. But that's still speculation there, and I am not a financial advisor, and this is not investment advice. So let's move on now. So we're going to go in to see exactly what it is that the SEC did here. So what's great is we're getting mainstream media attention. Now, Wall Street Journal just did an opinion piece on this. They say the SEC's cryptocurrency confusion. Regulators harm investors by filing suits before setting clear rules. I mean, they're just calling out the SEC. And there's one thing that's important about this that has to be said. This is not your CoinDesk or Cointelegraph or some random crypto media. This is the Wall Street Journal putting this out. So this is everyone on Wall Street seeing this. Now the SEC's starting to get a very negative reputation by doing this because they hide behind this. Oh, we're here to protect the investors. Everything we do is to protect investors. Now, the Wall Street Journal is saying, hey, you harm the investors by going overboard and overreaching in your attack. So instead of reading through this, I'm just going to play a little clip of describing what they said in this article. It'll be quick.
Court findings in the discovery phase of the suit have highlighted the inconsistency of the SEC's approach. In March, Magistrate Judge Netburn told lawyers that Ripple has a utility, casting doubt on the SEC's view that the tokens are principally a claim on future profits. And last week, Judge Netburn granted Ripple access to the SEC's discussions of Bitcoin and Ether, the two largest cryptocurrencies, which the agency considers exempt from its rules. The SEC believes Bitcoin and Ether aren't securities, in part because their developers don't profit from their sale. But those exemptions were announced through statements from former SEC Chairman Jay Clayton in 2019 and 2020, with no formal rulemaking. The findings by Judge Netburn in the Ripple case suggest that the agency hasn't set clear rules for which currencies it regulates and which it doesn't. This confusion poses risks for investors. Coinbase delisted Ripple after the SEC filed suit in December, prompting a sell-off that wiped out more than 60% of its value. The prices of Ripple and similar currencies have since tracked with the court statements on the SEC's case. U.S. participants in the $2 trillion cryptocurrency market are seeking clarity that the agency has declined to provide, preferring to announce its positions through individual enforcement actions.
So that's the Wall Street Journal saying that, calling them out. So now it even admits right here, it says in March, right here, in March, Judge Netburn told lawyers that Ripple has utility. I mean, they said it right in the case. She said it. And now, remember, there's two judges in this. There's the magistrate judge, Netburn, who handles all the discovery claims, and she handles the law on that side. Now, Anna Torres is the judge for the main case. But Netburn is the one who's going to make the decision here based on what the SEC did outside of the U.S. So it says, casting doubt on the SEC's view that tokens are principally a claim on future profits. That's obviously a load of crap because she's already admitted its utility. We know. I mean, you could just look at the stats right on the on-ledger Explorer. There's millions and billions of dollars that have been traded on the XRP ledger. And there's billions of payments that go through every day. So one thing that makes XRP ledger more of a currency protocol than Bitcoin and Ethereum, that makes XRP the currency, is that the XRP ledger has a payment network and an FX currency exchange with a matching order book execution that work simultaneously together. So it's more of a currency than Ethereum and Bitcoin could ever be because it has a built-in FX exchange with an order book with XRP as the counterparty list asset to provide liquidity. Yes, RippleNet has a enterprise solution called ODL, and it used to be called XRapid, that uses XRP as a bridge currency, but auto bridging is a native function on the XRP ledger and takes place all day long. Millions of dollars are traded on the ledger. So it's clearly a currency. All right, so let's move on from there now. And so the SEC claimed that Bitcoin and Ethereum aren't securities from Clayton and William Hinman, and then they backtracked on that. So, I mean, they're really digging themselves a hole now, and I think things are going to come out from the Coinbase. All right, so let's move on to, okay, this is a really good article too. It's Seeking Alpha, but I would like to just go into John Deaton's article here. And I've been in touch with John Deaton, talking with him, and I'm really excited about the XRP community intervening in this case. I think this is our chance to stand up for the retail investors, because this SEC is not protecting retail investors. They are just scorched earth, just trying to get wins, enforcement actions. They don't care about the retail investor. They're just saying that to go through with their enforcement actions. And now they're finally going to get caught. And this is the time. So let's read what John Deaton has to say here on a couple things. The SEC is misleading the court. Every XRP holder is a target. The SEC's attack on Ripple has been a case against all XRP transactions from 2013 to present day. That is not only clear message of the SEC complaint, but also in the precedence of its attack on other digital assets. Judge Netburn caught SEC prosecuting attorney Aurei saying it is clearly in court during a March 12th hearing. Every sale is a violation, he said. Judge Netburn pressed Thacher, who said, presumably, under this theory, then, every individual in the world who is selling XRP would be committing a Section 5 violation of the 1933 Securities Act, based on what you just said. Thacher scoffed at the judge's question, saying that retail holders of XRP are protected under the exemption of Section 4. Only the issue is the target. So, they've been fumbling this from the beginning. So let's move on a little more here. Just look at the case against... Oh, here's what he says. He says, well, we all know that isn't true. What is worse, the SEC also knows it isn't true. So the Telegram case here, the judge in that found that Telegram's offers and sales of its Gram token were an ongoing violation of Section 5. And when distribution reaches the public, the SEC can invoke jurisdiction and claim the public needs protection of the Securities Act. The term issuer means every person who issues or proposes to issue any security. That means any exchange who lists the token and any retailer who sells it to someone else. Thacher's attempt to mislead the court goes further. He was the lead attorney of the SEC in the Telegram case. He knows what he argued and what the judge ultimately ruled in that case. He can't claim ignorance in front of Judge Netburn or any of us. We are watching the case closely, and we are well aware of the stakes for us as holders of XRP, but more broadly as holders of all cryptocurrencies. Make no mistake, what happens in this case will have a major impact on the future of crypto, at least in the US. The absence of any protections granted or expressed for holders of XRP in the SEC's complaint against Ripple was deliberate. Now, see, that's huge. The SEC purposely or deliberately left out any protection for the XRP holders. If they wanted to reassure the millions of XRP holders, they would have done so at the beginning. To date, the SEC has not offered reassurance in any manner, not in Thacher's response to Judge Netburn, not in their reply or pre-motion letter, not anywhere. The SEC's mission to protect investors, maintain fair, orderly, and efficient markets appears to be in vain in this case. Their decision to establish policy by enforcement filing an 11th hour lawsuit not only sparked panic selling of XRP and delisting of token by exchanges, it fostered an uneven market by picking winners and losers and adding even more regulatory uncertainty. Now, also, don't forget that the Telegram case, the SEC sought and received a preliminary injunction preventing the company from using the funds raised from selling grams to build its Tone blockchain, noting its fundraising scheme violated existing securities laws. Notably, fundraising scheme used by Telegram is strikingly similar to the offering scheme Vitalik Buterin used to launch Ethereum. Also, curiously, ex-SEC Director of Corporate Finance William Hinman made it clear that in his eyes, ETH is not a security. So then, why go after Telegram? Perhaps the 1.6 million in payments William Hinman received from his law firm that sits on the Ethereum Enterprise Alliance during his tenure at the SEC had something to do with it. All right, we're just about the end here of this thing. And then I'm going to go into some other things that I think, will offer a little speculation and where I think this is going. I have said from day one, this is Deaton speaking, I am not an expert on crypto nor securities laws, but it doesn't take an expert to see that there's plenty is very wrong, very corrupt, very outrageous about the SEC's lawsuit against Ripple. I hope that clarity is on the horizon, but I fear that for the retail holders represented in our case, the fight has just begun. So, wow. So, Deaton's really laying it down right there. So, now here's an article from Seeking Alpha, which really hammers down the same thing with the SEC. Regulatory uncertainty is becoming increasingly problematic for escalating number of startups. The SEC lawsuit decimated XRP's value. We all know that. The more enormous potential for innovation in the new financial sector in widening the options for safeguarding value, despite headwinds bullish on XRP and the broader crypto market. So now here, there was one part that was really good here that I wanted to discuss. The regulatory void. The Commission's recent enforcement action has not only boggled observers with its bravado, but also sent a chill throughout the industry. Previous SEC leadership presided over a period of enormous growth and expansion. Nevertheless, the agency steadfastly refused to propose any new rules to give any clear guidance on how it should be treated and took increasingly hostile actions against developers in December 2020. The SEC filed a lawsuit against XRP. We all know that. Let's move on to right here. Okay, here we go. This is the good part. So they describe how when you're building a network. So cryptocurrencies projects take time to build. Constructing a network and an ecosphere for a blockchain ledger to do something innovative and disruptive is a process. This usually entails distributing many tokens so they can provide liquidity. Now, Ripple is not a lender of last resort. They are a liquidity provider of first resort. Remember that. Liquidity provider of first resort. They're not lending of last resort because they don't have a country to support. The process is similar to installing plumbing and electrical systems when building a new house. Unfortunately, the SEC has not been a helpful home inspector, checking on progress and dispensing clear advice. To cryptocurrency startups, the SEC has been more like an outside observer, arbitrarily deciding when to tear down the structure and start over. To those investors inside the house, they have no indication of what the SEC plans to do next. This is the opposite of fair and orderly. That's exactly what their mandate is. Fair and orderly markets. They're doing the opposite. The SEC was repeatedly asked if XRP was a security or not. And for years, it steadfastly refused to answer. And there's clips of basically Glenn Hutchins asking Clayton directly, NBC asking directly, never said a word. The commission stood and watched as billions of XRP tokens were sold on secondary markets by millions of retail holders who had no connection to Ripple. The regulator also witnessed the division of the Treasury Department classify XRP as a currency in 2015. The SEC still had nothing to say. Didn't this action of no action actually set precedent? Actually, the SEC took the request from cryptocurrency exchanges years before the lawsuit. These exchanges were persistently asking for clarity on XRP, as well as permission to list the token for trading. An outstanding 7 years went by as the XRP ledger became a full-fledged and decentralized network before the SEC suddenly announced that Ripple, its executives, and every retail holder worldwide should have known for the last 7 years the token was an unregistered security and that it had all broken the law. This was devastating to those investors that purchased XRP. I mean, they deliberately did this right here. The SEC has shown from the beginning the agency believes that the lack of clarity on cryptocurrency regulations is why it will prevail in the case, no matter how illogical its reasoning becomes. Like with every enforcement action against entirely new asset class, the SEC relies on tortured interpretations of the 1933 Security Act, a law enacted when blockchain innovation was never imagined. The enormous potential, well, here's the thing, is something has to be done here. And this is now getting, this is my words, getting out of control, because we have the Wall Street Journal, we have Seeking Alpha, we have law firms. This is all over Twitter. Gary Gensler is now just coming in. So with this new thing that came out, which we're going to talk about next, I think we could skip through this now. The enormous potential for new innovation in a new financial sector, widening the options for safeguarding value and creating distributing wealth will continue to be hindered due to the confusing, unnecessary regulatory void, unless Congress and the Biden administration take the opportunity to end this tragic cycle of regulatory uncertainty by implementing a clear set of rules for everyone. These contemporary rules must acknowledge we have entered a new technologically driven world. Antiquated analogies to orange groves or soybean fields from 80 years ago are mute. So even look at that. These articles are just coming left and right. So now here's actually the here's the thing with what Ripple wrote to Judge Netburn. But before that, let's talk about this guy here. This guy, former SEC enforcement, just happens to be joining Simpson and Thacher. So the former acting head of Securities and Exchange Commission's enforcement, Mark Berger, is being hired by the law firm with the Ethereum Foundation. Like, go figure. I mean, this is like corruption all over the place here. I mean, it's getting a little out of control. Like, it was Hinman, then it was Clayton, now it's this guy. He will join as a partner starting in June. In January, he stepped down from overseeing the 14-member enforcement division. It just happens that everybody stepped down right when this case was going on. Clayton left, Hinman left, the two other enforcement directors left. He stepped down from overseeing the SEC 1,400-member enforcement division, which Clayton put 2 co-directors in there, not 1. And Berger also headed the agency's New York office from 2017. He was named Deputy Director of Enforcement in August 2020. So he basically was the one who was behind this case. An assistant U.S. attorney in Manhattan. All right, we can move past that. But it goes to show these people, like, they had ulterior motives here. So now on to what happened with the recent letter to Judge Netburn from Ripple. Basically, Ripple said, concerning the SEC's undisclosed and pervasive use of SEC pre-litigation investigative tools to conduct discovery in this lawsuit. Specifically, defendants learned, not from the SEC, as would be required, but from overseas third-party business contacts, that the SEC is pursuing discovery entirely outside the scope of federal rules and the Hague Convention by improperly leveraging memoranda of understanding with foreign regulators, who then, at the SEC's request, serve burdensome documents requests on entities under the foreign regulator's jurisdiction. In response, defendants' repeated inquiries, and as of our meet and confer on April 14th, the SEC finally acknowledged that it had made at least 11 memorandum of understanding requests seeking documents from overseas entities, many of whom to appear Ripple's foreign business partners, or at least 10 foreign regulators across the globe. It's just amazing. It really is baffling that the SEC is able to get away with doing this. All right, let's move on. So the SEC should be subject to the same federal rules as every other litigant before the court. The SEC is not a super litigant who is permitted to act outside of the federal rules. Not only is use of pre-litigation investigative tools prejudicial to defendants and the recipients of such requests, as described below, it prevents the court from exercising its lawful discretion regarding the scope of permissible foreign discovery. So here's the point, is the SEC did this without the discretion of the court. So this Judge Netburn, she's going to be pissed. And let's move on here. The SEC may not conduct discovery outside the scope of federal laws. It's basically what they're saying. And Ripple's asking the court that the SEC should be ordered to cease all use of memorandums of understanding request in this action and withdraw all memorandums of understanding from foreign regulators. So just to break this down of what they're doing, they're asking the regulators from these countries here to serve subpoenas to the business partners of Ripple in those jurisdictions who already have clarity. Now, are they doing this to get information? It sounds like a scorched earth, just fishing expedition. This is a civil case now. You know, we'll go into it more here. It's frustrating talking about this because the SEC has now crossed another line. The Wall Street Journal is talking about it, Seeking Alpha. You got John Deaton, the community, calling them out. Even the Wall Street Journal saying that they hurt the community. Like, the SEC's in big trouble right now. So let's see if Ripple could take advantage of this, and we could see Gensler say, all right, enough is enough. Let's drop this because this is getting out of control and they're embarrassing themselves. If not, the SEC is going to be the ones who step in and, you know, I just hope it's Gensler who steps into the SEC and just ends this right now. Or Congress. One of them have to do it. All right, so moving on here. The SEC has agreed to share substance, but they refuse to cease the practice and likewise declines to produce copies of its memorandum of understandings with foreign regulators. Defendants will seek to ask the SEC to send a copy of the motion to all foreign regulators with whom it has pending memorandum of request so that they are on notice of defendants' challenge of the SEC's practice. So basically, they're asking them to cease these MOUs, and they're also saying, let them know that, hey, this is being disputed by Ripple and the courts, so don't be sending everything. All right, so moving on. The MOU process involves foreign securities regulators. We know that, which has a significant impact on the recipient of the requests, including Ripple's overseas business partners, and amounts to an unwarranted intimidation tactic here. The SEC's MOUs with foreign powers represent an extraordinary tool to which private litigants like Ripple or Mr. Larson Garlinghouse have no equivalent and which has no place in litigation. And it represents an end around the court's authority to oversee the extent of foreign discovery necessary in litigation. So they're basically definitely abuse of power going on here. And then the SEC goes as far as citing something, and they contradict themselves. They actually said that it's a misuse of the SEC's investigative power. In the SEC enforcement manual, even the SEC itself does not blanketly approve the use of MOU requests in all cases, but instead requires an internal case-by-case determination of whether to utilize its MOU powers in a particular litigation, signaling a recognition even within the agency itself that its ability to use such power is questionable at best. Similarly, courts have admonished the SEC for seeking discovery after the commencement of litigation. So they did this after it started, it looks like. But I'm sure this was ordered by Jay Clayton, or Lizard King over there. The SEC, citing testimony, the SEC regulations restrict the use of broad SEC investigative powers during a civil litigation. Remember, This is civil. This isn't criminal. This isn't fraud. It's no scams. It's just civil accusation. To prevent abuse of those powers once civil litigations has been initiated. For the same reason, the SEC cannot use its own administrative subpoena power domestically in the litigation context. It should not be permitted to invoke analogous compulsory powers of foreign regulators abroad through the MOU process. Defendants do not dispute the SEC's right to conduct informal interviews, but rather its ability to issue compulsory process over and beyond the discovery permitted. MOU process is available only to the SEC, not to defendants. This creates a fundamental inequity in litigation. Neither party should be permitted to exercise those powers. So we're moving through this, and then I'm going to throw my opinion in there. So just hang tight. The SEC has not opened a separate regulatory investigation into allegations beyond the scope of the amended complaint. See, and I bet you they're trying everything to find anything possible, and they're not finding anything. There's nothing there to find. So it seems like the SEC is doing everything in their power, going out of their way, using all these resources. And it even says it here. It said the SEC is exploiting the MOU authority to do exactly what the agency decried in Honig, to gather additional evidence to support amended complaint charges. This is improper. Now that Ripple asked, Your Honor need not reach the issue because the circumstances of this case, as these tools patently unfair and unreasonable here. This is not a case where the SEC seeks targeted foreign discovery from a single critical witness. Rather, this case is where the SEC's discovery approach can only be described as scorched earth. So here's where Ripple describes. They spent 2.5-year investigation in which they obtained almost 100,000 documents, approximately half from the defendant, half from third parties, 159 unique document requests to defendants in this action, at least 56 third-party subpoenas, including subpoenas directly to essentially all of Ripple's substantial business partners and individual defendants, financial institutions. Foreign discovery, the scope of which remains unknown to defendants due to the SEC's refusal to provide any visibility. It invokes at least 11 unique entities. So Ripple heard about this from those business partners, but they don't know the details of the 11 unique entities. They don't know all of them, at least 10 foreign regulators. The SEC is seeking discovery from at least 67 third parties around the globe. Even more problematic is the SEC has issued memorandums of understanding to obtain burdensome foreign discovery through regulators from entities in the UK, Japan, and Singapore, 3 jurisdictions where SEC has been determined to be a virtual currency, not subject to securities regulations. This has had a significant chilling effect on Ripple's commercial and business operations with partners in those jurisdictions who have received requests from foreign regulators relating to this action. The SEC has further violated federal rules by refusing to give notice to defendants and produce its request and related communications with foreign regulators. After the SEC filed suit, Japan's Financial Service Agency, the country's top securities regulator, confirmed that its views as XRP is a cryptocurrency and not a security. I love how they throw that in there. And then you have the UK stating in 2019 it's a hybrid exchange utility token, leaving it outside its regulatory perimeter. The Singapore also issued legislative guidance based on the conclusion XRP is a virtual currency. So, I mean, how much more is there here? I mean, the SEC is literally, I think, at the end of their ropes. They went to too much extremes here. And this is what now Ripple asked for. Defendants respectfully request a conference with the court and seek an order requiring the SEC to withdraw its outstanding MOU requests to foreign regulators, cease conducting discovery by MOU requests to the extent that the SEC has obtained or reviewed any documents to date as a result of such procedures. Produce the underlying MOU request and related communications with foreign regulators. Boom. So Ripple is definitely firing back at this moment right now, and I love it. I really do love it. So now I want to throw out my opinions on this and what I think is going on. I know this is a long video today, but I think it's very important. With Gensler coming in now, the SEC in shambles, basically. Gensler is going to have to clean up this mess, because this is now a mess that's happening. I think we're going to see Brad and Chris's accusations or charges against them dropped. Netburn is going to get really upset over the SEC overstepping. It's starting to get public attention on Wall Street. Congress has known about this. This is now going too far. Now, Ripple has tons of ammunition still when they go to actually, litigate this case, because we're really only in discovery right now with that. And we got John Deaton coming in, who's going to be intervening on behalf of the XRP holders. There's no way the SEC is going to be ever able to prove that XRP is a digital security now. Deaton is going to obliterate any argument, because there's just an overwhelming, abundant amount of facts that just completely decimate what the SEC is trying to say. So they're going to take a loss there. He's sending his thing, and I think April 19th, he said. So tomorrow that has to be submitted. They receive that. The SEC gets a chance to respond. But now in the meantime here, you got this going on where the Netburn is going to really flip out and say, hey, you guys went way overboard here. I'm not a lawyer. I'm not an attorney. I don't know what the consequences necessarily could be, but they're going to be very negative. Let me put it that way. It's going to be damaging to the SEC image. It's going to be damaging to the case. And now on top of this, Brad and Chris's case are likely to be thrown out very soon. So that's coming. We have Deaton coming in there and also trying to intervene as the XRP community. We're ready to crush that. So my belief here is, regardless of whatever happens in the end with Ripple and the escrow thing, that's the next discussion. I believe in the next couple months or shorter, we're going to get XRP is going to be the one asset that gets full clarity. That it's absolutely not a security. There's nothing about it. It's deemed the only asset that is truly, by law, not a security. That changes the game. Like, it flips everything upside down. Like, Ethereum and Bitcoin are not officially classified as not securities yet. Only Jay Clayton and William Hinman said that. But it's not set in stone. It's not law. The SEC hasn't put out an official statement. What's going to happen with Deaton when he gets in there, he's going to force them to either put out a statement that XRP is clearly not a digital security, it has clear utility, or the judge is going to bring it right to summary judgment, and that's it. It's going to be in law then that XRP is a virtual currency or it's not a digital security. That means all relistings happen. Boom. We're all relisted on all the exchanges. And all these partners, corporates, are going to be more likely to use XRP even than Bitcoin, Ethereum, because it has 100%, without a shadow of a doubt, clear clarity. There's no going back on that until Congress gets its act together and passes a regulatory framework. So Brad and Chris's thing is definitely getting thrown out because there's no way they could prove that. Then the only thing left would be, is the SEC going to be able to prove that Ripple sold XRP in the early days as an investment contract? I don't know. I don't think they're going to even be able to get there because they're going to embarrass themselves so bad with these two things. And I do want to also stress, do not expect a settlement. I'm going to keep repeating this. The reason why don't expect a settlement, Ripple's not going to settle because they're winning, number one, and they are not going to give up that escrow or any disclosures about that escrow. A settlement would mean they would have to give disclosures about what they do with all their escrow to the SEC, what they personally do with that. They're not doing that. So this is why, throw that whole settlement thing out there, because I'm saying that not as a lawyer, I'm saying that as a deep dive researcher who studied XRP, Ripple for 3+ years. They're not settling unless it's like literally, they're not going to admit any wrong now since they're winning, but they're not going to do anything with the escrow. Everyone that I see on Twitter saying, oh, they don't want retail to hold XRP, get over that. That's a load of crap. We have Flare coming. Facts, facts, facts. Flare is going to allow any retail holder to mint FXRP, bring it on the Flare network, earn yield, and utilize it. Nobody's taking away your XRP. The escrow is not going anywhere either. The escrow is going to be not burned, not handed over, not sold. Remove those 3 things. What is it going to be used for? The same way all the other supplies are used in other crypto asset networks. This is game theory, crypto economics, token economics. It's seigniorage. You could incentivize the behavior of the networks, incentivize liquidity. Ripple is not a lender of last resort. They're a liquidity provider of first resort. I foresee I foresee it already happening now. When that escrow is released, it's released into other like smart contracts that are outside the XRP ledger that release the XRP based on certain conditions that are met within the network or based on certain entities. And I think it could be even more complex than that. Since Flare Network has the Flare Time Series Oracle built into it, it is price feeds. So the escrow could release based on the price, not counting on Bitstamp's price, not the Nasdaq's liquid index. That's all crap. The decentralized price feeds are the most accurate price feeds. So the Flare Oracle has XRP USD price. If XRP hit a certain price, X amount can be released from that escrow to based on certain conditions to satisfy liquidity, reward for liquidity, reward for locking up. And remember, FXRP, when it's brought to the Flare network, that's going to lock up a lot of XRP. We want more use cases for XRP, continuously more. I see Ripple moving into the insurance. They keep talking about insurance. Now, also, digital identity is going to be big. And liquid democracy with Flare, I'm going to be doing a video on that tomorrow. It's not something that appeals to everybody, but liquid democracy is huge. Like, I think that's the future of, like, the politics. It's revolutionary in its design because you could vote directly or you could delegate your vote. Unlike the systems we have now, where you just have to vote for one person and then they vote for everything for you. But direct voting is too much. So that in between, where you could pick who's an expert in a field, then they vote for you. And you could delegate your vote to them. And you're not stuck with just one. Well, this is how, whatever happens in real politics, don't expect that for a while. But in these community-based networks that have real governance, every Spark holder has a governance vote. And they vote on the parameters of the network. And I think we're going to see that more and more. And I think liquid democracy is a powerful new type of governance that's going to play a major role in the future. So also I want to let everyone know, Brad Kimes and myself will be interviewing the creator of Trustline Credit Network and the Probity Vault, which issues the Aurei decentralized global stablecoin that we've been talking on this channel for the past few months. So we'll be interviewing him on Brad Kimes' Digital Perspectives channel. I will post a link. I'll post it on Twitter. I'll make everyone aware tomorrow. That video is probably going to be released on Tuesday on Brad's channel. Really looking forward to that. We got some great questions. If you haven't seen my video I did yesterday on Trustline Credit Network and the Probity Vault, I did a deep dive into the documentation of what it is. And it really is, this is the next level of DeFi. It's complementary to Flare Finance. It's got a lot of similarities to the traditional banks. Basically, it's a autonomous, decentralized community crypto bank on the Flare network. That's what Probity is. Trustline Credit Network is a fiat on-ramp, off-ramp that will allow, that's on the XRP ledger, that will allow credit, to issue credit. So instead of credit cards, you can have revolving credit using the Aurei stablecoin that gets loaned out. So you put your FXRP in, then you loan out your Aurei stablecoin, which you minted from putting the FXRP in. But here's the kicker. While your FXRP is in this bank vault, you're still earning your daily Spark rewards at no risk. And then you loan out that stablecoin, which provides liquidity and credit to the Trustline Credit Network. And then you get earned interest in a super premium semi-stable governance token called TCN, which is a revolutionary new design. So we're going to talk about that in the interview. We're going to talk about what the vision is. And now this is a former RippleNet integration engineer for Amex, BBVA, PNC Bank, Banco Remento, some big names. So he has a experience working in RippleNet with the hosted solution and integrating into banks. So Trustline Credit Network is on the XRP ledger and on the Flare network. Probity Vault is built on Flare. The Aurei stablecoin is issued on the XRP ledger and it can be on Flare. It is based on the blog post from Flare Network, Closing the Circle of Interoperability. So I will post that video at the end of this video and also in the description below. And I'm Mickey B. Fresh, and I'm out.